light of the recent cyber attacks at the Five Eyes Global Economic Summit, we are here today to gather an understanding of the information and data collected throughout the investigations. In order to do so, we will be hearing from 5 digital forensic experts. Let's begin. Our first testimony will be from the security policy analyst, George Chiari. Mr. Chiari, what are the legal challenges associated with cyber incidents involving foreign countries, and how do internal laws affect e-discovery?
Hello, my name is George Carey, and I'll be looking at the legal challenges associated with cybersecurity incidents involving foreign countries, how internal law affect e-discovery, and lastly, we will discuss all the international laws that may influence a forensic investigation in Australia. Let us begin by looking at legal challenges associated with cyber incidences involving foreign countries. The international law offers guidance on handling cyber incidences that may be carried out by a state against the other. The approach of international law to cybersecurity are mostly based on jus ad bellum or jus in bello doctrines. The jus ad bellum doctrine explains when a state can exert force against another. Article 51 of the UN Charter allows states to practice self-defense when they suffer an armed attack. Article 24 prohibits the use of force against territorial integrity of another political state. However, the application of these laws in the case of cyber conflict results to issues such as whether cyber operations constitute an armed attack as described in Article 51 and whether states can act in self-defense. DDoS attacks that temporarily result in the disruption of non-critical infrastructures does not constitute as an armed attack owing to its scale and effects. The implication is that very few cybersecurity attacks meet the threshold of international armed conflict to mandate states to act in their self-defense. Another legal issue is applying international humanitarian law to solving transnational cybersecurity incidents is the application of the state responsibility doctrine. Historically, if an attack was advanced by a foreign power, the state will be held responsible. However, the cyber attack can have minimal cost to the state by engaging hackers with government ties or individuals with the ability to hide their IP addresses, and therefore holding a nation responsible for cybersecurity incident is difficult in the cyber world. The third issue is that domestic criminal law does not apply to transnational cyber offenses as these have effects that transcend states' police power. Law enforcement encounters problems in policing crimes involving several jurisdictions. Specifically, different countries have varying laws on cybercrime. The internet users are only bound by laws and norms of the residential country and not of foreign states. Most domestic cybercrime laws are not extraterritorial. As such, exercises of authority tends to infringe on sovereignty of other nations. Lastly, enforcement jurisdiction also poses a threat to the mitigation of transnational cyber offenses. Other nations may not be willing to provide the required digital evidence for investigations. The enforcement of cybercrime statutes require resources and expertise that not all states possess. For instance, developing nations may lack the ability to effectively investigate and prosecute cybersecurity incidents or help in cross-border investigations. Moving on to effects of internal laws on e-discovery. E-discovery is the pre-trial legal process that describes the method used by various parties to acquire and review information that is electronically preserved. The 2006 Federal Rules of Civil Procedure seeks to ensure that information stored electronically tallies with the paper document presented at the court of law. Internal laws affect the process of e-discovery as they delineate the obligations of various parties to discover and disclose documents to other parties and range of documents that can be used in a civil proceedings through the federal courts. Let us now move on and now look at the laws that may influence a forensic investigation in Australia. The first law is the Forensic Procedure Act of 2000. This offers details on how to undertake a digital forensic process to ensure the acquired evidence is admissible in a court of law. The Australian law has a provision that allows the law enforcement agencies to access data without requiring a formal warrant. For instance, a cloud service provider are necessitated to offer reasonable assistance under Section 313 of Telecommunication Act 1997. However, it is also possible for Australian law enforcement agencies to issue a warrant under Telecommunication Act of 1979 to enable them intercept telecommunication in real time and allow them to access information stored on a cloud server. The Crimes Act of 1914 contains specific provision that guides law enforcement on conducting evidence searches and seizures as related to electronic searches and when such documents should be availed. Section 3E of the law offers information on what the warrant can authorize, while Section 3F analyzes the various powers that are available to constables to issue such warrants. Section 3J enumerates on use of equipment in the examination and process stage, while Section 3K enumerates on use of electronic equipment at the scene. In case the required evidence is hosted and stored outside Australia's jurisdiction, law enforcement agencies can issue a mutual assistance request through their Federal Attorney General. This enables them to attain evidence in a form that is suitable for admission in court as provided under the country's Foreign Evidence Act of 1994. However, the access to the information is regulated through the Mutual Assistance in Criminal Matters Act 1987, which provides sufficient protection to ensure that access is in line with the country's values.
Thank you, Mr. Chiari. The next expert testimony will be from security engineer Jenny Hobbs. Ms. Hobbs, what are the legal challenges of accessing and retrieving electronic evidence stored on foreign soil? And assuming cloud storage was used, what procedures were followed to access and retrieve digital evidence stored in the cloud?
Evidence on foreign soil poses legal challenges as laws in other countries differ from our own. The Clarifying Lawful Overseas Use of Data, or CLOUD Act, was established into law in 2018. The CLOUD Act allows federal law enforcement agencies to compel US technology companies to reveal electronic communications or documents stored in the cloud, regardless of where in the world that data is physically held. The Act also covers how other countries can request data from the US government through executive agreements, such that foreign countries can make similar requests for information from US technology companies. The CLOUD Act does allow for the technology companies to challenge requests if the company believes the request is contrary to the host nation's laws or national interests. Where data is held by non-US companies, or where the CLOUD Act cannot be otherwise enforced, a Mutual Legal Assistance Treaty, or MLAT, can be made between the United States and the host country. MLATs allow the host country to assist US law enforcement agencies with the request for data, but it allows the local country to act within its own laws to do so. Under the CLOUD Act, to gain access to digital evidence in the cloud, either the user's permission or a United States court warrant must be procured. The warrant must be specific to an investigation and detail the data being sought. Once procured, the warrant must be presented to the technology company, which must then turn over the requested information or file a challenge if the company believes the request is not in compliance with the laws in the nation where the data is hosted. Using an MLAT, the United States must prepare a draft request and submit it to the Office of International Affairs for approval. Once revisions have been made per the Office of International Affairs, the request must be submitted to the Department of Justice for an authorizing signature. The signed request is then sent back to the OIA, and the OIA files the request directly with the foreign nation specified in the treaty. The request is now complete, and the foreign nation is bound, under the MLAT, to assist.
Thank you, Ms. Hobbs. You may take your seat. Our next question is for Cybersecurity Policy Analyst Hina Khan. Ms. Khan, specific to Australia, how did the international laws and jurisdictions influence the processes and procedures followed during the forensic investigation?
To ensure that the summit was a success, the team presented a digital forensic environment review and analysis of Australia's laws and regulations. The laws of the host nation were also analyzed to confirm that their cyber standards reflected the same values as Australia's, should an incident occur during the summit. According to Australia's International Cyber Engagement Strategy, which was developed by Australia's Department of Foreign Affairs and Trade, a multitude of issues were addressed from trade to cybercrime to encompass both international security and cooperation in order to adopt an all-inclusive and organized approach to cyber affairs. Australia's government has developed standards and guidelines to promote secure and stable cyberspace for their users. Although the existing international law does provide a good framework for the country's cyberspace behavior, they have clarified where they stand in reference to the challenges of sovereignty, attribution, and jurisdiction, since there are a range of different activities engaged in cyberspace across multiple national borders. They recognize that the UN Charter and international law on seeking peaceful resolutions of settlements must be followed. Unfortunately, Australia's law enforcement does not have jurisdiction to take action unless the criminal or device resides in Australia, or with regards to email, the computer server of the company that provides the email service is located in Australia. Now, that did pose issues during the forensic investigation, causing delays in information gathered in some scenarios, unfortunately. The only way to get around that was to make sure that the team itself was well prepared and did everything that they could do at their end. That being said, there were agreements amongst the nations that helped to ensure that they were working together to assist in capturing and stopping cyber attacks. The Protective Security Policy Framework by the Australian Government's Attorney General's Department provides the security governance for international sharing. It specifies protections for valuable information and assets identified within various international sharing agreements that Australia is a party to. The host nation's standards and policies were reviewed to ensure that Australia and the host will be able to collaborate successfully during the summit. After reviewing their position on applying international law to their cyberspace standards, it was apparent that the host nation's laws and regulations are parallel to those of ours.
Thank you for your testimony, Ms. Khan. Next, we'd like to hear from Security Training Officer Hannah Cormus. Ms. Cormus, what conflicts arose between ethics and international laws during the forensic investigations, and how did these conflicts affect the investigations? Also, how were the conflicts mitigated or resolved? It's always important to respect the laws and regulations of all countries when conducting any type of investigation, not only to ensure that it results in a success, but also to create and maintain friendly relationships with those nations involved. Because cybercrimes are not confined by boundaries and can occur anywhere and by anyone, it's difficult to dictate jurisdiction. That being said, with regards to the attacks on the Five Eyes Summit, we not only followed our country's best practice guidelines, but also that of the host nations, as well as not impeding on the other nations' procedures when they conducted their own investigations. While Team Australia launched our own analysis of the attacks in accordance to the standards and procedures governed by the Australian Government Information Security Manual, we made sure to follow the international standards developed and published by the International Organization for Standardization and the International Electrotechnical Commission. While all countries participating at the Five Eyes Summit did their best to follow these guidelines to minimize impact and uncover the attribution actors responsible and/or contributing to the attacks, it became a little difficult to work together once suspicions arose after discovering that the malware was distributed internally. This essentially resulted in all parties beginning to shut down communications, both verbally and via network, to protect themselves. That being said, rather than going on the cyber offensive, which could have jeopardized our relationships and even prolonged investigations, Team Australia elected to share the knowledge we had to help each other. Though we did not know the source attribution at the time, we recognized that we all shared two very similar goals: to secure our assets and to protect our citizens and stakeholders. Through knowledge sharing, we were able to minimize impact, protect our assets, and expedite the investigation by giving each other insights on the situation, which in the end not only yielded positive results, but also strengthened the relationships. Thank you, Ms. Cormus. Our final testimony will be from cybersecurity and information assurance expert Angelique Harris-Bala. Ms. Harris-Bala, what steps were taken to protect United States soil and citizens during the international investigation? Describe any risks to the country, businesses, or citizens from your investigations.
Steps taken to protect United States soil citizens during international investigation: protecting critical assets using cybersecurity scams that authenticate configure requests with 128 bits, AES encryption on all configuration and control functions, creating cybersecurity awareness training for employees to aid them with knowledge and skills requests, prevent common attacks types such as phishing attacks, inside threats, and social engineering. Access control mechanics to restrict user access and to decrease the chance for successful attacks. Password policy that requires users to create complex passwords containing a combining of numbers, alphabets, both lower and upper cases, and special characters. The password should be changed at least after every 90 days. A wide culture change that emphasized the need to continue improving to the cyber resilience across the critical infraction sectors. Employees and vendors should be evaluated for potential cyber risks, including screening for malicious actors, engaging supply chains, potential functions, ensuring supply follow application security practices, and reducing the number of vendors' access to crucial information. Risks to the country, business, or citizens from the investigation. The country faced risks of cyber espionage, such as from the malicious actors, Dragonfly, the attacks different sectors, including the energy sector. This forms of attack backing by natural state can gather information and potentially set a platform for future attacks. Citizens can suffer from power outages when the supervisor controls data. SCADA systems are illegal across the affecting during the investigation, which can also aggregate affect businesses that rely heavily on power utilities. If power went out across large regions for an extended period, highly dependent systems such as communication, finance, transportation, water, and sewer networks will be seriously impacted, leaving businesses and citizens immobile and incognito. Attacks using social engineering, baiting, and other inside threats can be restricted authorized access to critical infrastructure.
Thank you, Ms. Harris-Bala. You may now take your seat. This concludes the round of questioning. We now have a better understanding of what has occurred, as well as the situation itself. We greatly appreciate the time all of the expert witnesses took to appear in court today. Thank you all.